Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. It is 8 o'clock in the morning, and I am shooting a video here at the office. Don't think I've ever done that before. Why is that? Well, we have a huge, and I do mean huge, ruling out of the United States Supreme Court in the matter of Loper Bright Enterprises versus Raimondo. We have been talking about this case for over a year now. This is a huge case. A lot of people don't realize just how big this case is. As a matter of fact, I'm going to venture to say that this is the biggest ruling to come out of the United States Supreme Court since the Dobbs decision. The Dobbs decision was the one that overturned Roe v. Wade. The Chevron deference is dead. It is dead officially today, and that not only significantly ties the hands of the ATF behind their back, but also all the other alphabet agencies. I cannot express to you just how big this ruling is. So today, let's start geeking out on the opinion. Let's spend a few minutes and talk about the Supreme Court issues its biggest ruling this year. Okay, hey, before we get going too far down the road, we're going down. Let's spend a minute and talk about federal agencies, because as we know, today was a bad day for all the alphabet agencies, and it's because, well, we've unconstitutionally delegated far too much power and authority, and the Supreme Court has finally reined that back in. Ask yourself, do you trust the ATF? Of course you don't. That's why you're watching this channel all the time. Do you trust the CDC in the post-pandemic world? Well, how about the FDA? Do you trust the FDA? Of course you don't. Well, maybe that's why you guys should all find out about what's got all the folks at the FDA spooked by what the folks at Black Forest Supplements are doing. See, it all comes down to nicotinamide mononucleotide, or what they call NMN. Now, you see, NMN, which is just a natural supplement, produces more NAD+. What's the benefit of NAD+? Well, that's going to help you with your cellular metabolism, your energy production, and how you age. And listen, if you want more NAD+, well, it's just as simple as taking more NMN. And if you do that, you will see tremendous health benefits. And these benefits include increased energy, better weight control, stronger endurance, better strength, and yeah, you're going to age healthier. And hey, listen, you don't have to believe me. You could just go ahead and check out the two studies that we're going to link up down below. One from Harvard Medical School, the other one from the National Institutes of Health, which talks about the tremendous benefits of NAD+. As a matter of fact, the study suggests that it will also assist with cholesterol management and blood pressure. But you see, America, here's the problem, because now the FDA, well, they want to turn NMN into a prescription medication. They want to pull it off the market so that they can have a monopoly. Why is that? Well, it's pretty easy to figure out. Number one, they'll make sure that Big Pharma continues to make billions and billions of dollars by shoving more and more pills down the throats of Americans. And the other truth is that if we as a country started taking better care of ourselves and start aging healthier, well, then they're just not going to have the need to keep shoving those mountains of prescription pills in you that they currently do. So if you want to find out more about the benefits of Black Forest Supplements and what they can do to improve the quality of your life, go ahead and click on that link right there, or better yet, scan that QR code. And right now, for a limited time, if you visit our good friends at Black Forest Supplements and you buy 2 supplements, you will receive a third one free. For more information, visit our good friends at blackforestsupplements.com. Okay, America, this is what we are talking about, and we've been waiting for this one for a long time. We are talking about the matter of Loper Bright Enterprises v. Raimondo. As you can see, a nice light read this morning. The opinion came out just a little over an hour ago. I've had a chance to skim through it. We're going to get right to it, but let's just get everyone to understand just how important this is. Back in 1984, the Chevron case was decided by, at that time, mere 6 justices that heard that case on the United States Supreme Court. They basically said, hey, listen, when it comes to technical terms and trying to interpret statutes, we're going to defer to the administrative agency tasked with enforcing it. Translation, we're going to delegate authority away from the courts and back to the executive agency. Translation, we're going to go ahead and violate the separation of powers. Now, interestingly, this case has not been decided on a separation of powers doctrine, but once again, the Administrative Procedure Act has reared its head to save the day here, because this case has actually been struck down on Administrative Procedure Act grounds. Now, when you think about it, when you think about these three unique branches of government and how they're supposed to operate, giving deference to an executive agency to interpret laws does seem to be allowing the agencies to get a little bit outside their lane. It's one thing to give them respect, it's another thing to actually defer to their findings. And so as Chief Justice John Roberts, who is the author of this opinion, pointed out, respect, though, was just that. The views of the executive branch could inform the judgment of the judiciary, but did not supersede it. In cases where a court's own judgment differed from other high functionaries, the court was not at liberty to surrender or waive it. Now, we had predicted that this was going to be a 6-3 vote, which is exactly what it turned out to be. It went down exactly as the way, but the grounds upon which the Supreme Court has thrown the Chevron deference out, well, we were wrong on that. We'll just be honest. We thought it was going to be really under a structural argument of how our country was intended to function. Instead, it comes down to, once again, a piece of legislation drafted and passed in 1946, the Administrative Procedure Act. Congress in 1946 enacted the APA as a check upon administrators whose zeal might otherwise have carried them to excess not contemplated in legislation creating their offices. The APA prescribes procedures for agency action and delineates the basic contours of judicial review of such action. And it codifies for agency cases the unremarkable yet elemental proposition reflected by judicial practice dating back to Marbury that courts decide legal questions by applying their own judgment. As relevant here, the APA specifies that courts, not agencies, will decide all relevant questions of law arising on reviews of agency action. And there actually is a statute that says exactly that. That is 5 United States Code Section 706. As the Chief Justice points out, it prescribes no deferential standards for courts to employ in answering those legal questions, despite mandating deferential judicial review of agency policymaking and fact-finding. And by directing courts to interpret constitutional and statutory provisions, without differentiating between the two, Section 706, it makes clear that agency interpretations of statute, like agency interpretations of the Constitution, are not entitled to deference. So, does that mean that the courts are to absolutely, positively ignore what the administrative agency is saying about how they interpret the statute? Absolutely not. That is not what the court is saying. What the court is saying is we're not going to allow the judiciary just to defer to them. As the Chief Justice put it, courts exercising independent judgment in determining the meaning of statutory provisions consistent with the APA may, as they have from the start, seek aid from the interpretation of those responsible for implementing particular statutes. And when the best reading of a statute is that it delegates discretionary authority to an agency, the role of the reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits. And so ultimately, where the Chief Justice and the majority of the Supreme Court has come down is the following. The deference that Chevron requires of the courts reviewing agency action cannot be squared with the APA. Chevron, decided in 1984 by a bare quorum of 6 justices, triggered a marked departure from the traditional judicial approach of independently examining each statute to determine its meaning. And the court points out that, listen, when Chevron was first decided, it wasn't really a landmark decision. It was an important decision. But over time, we began to make a much bigger deal out of it as we began to unlawfully delegate more and more authority to executive agencies. So as the Chief Justice writes, although the court did not at first treat Chevron as the watershed decision it was fated to become, the court and the Court of Appeals were soon routinely invoking its framework as the governing standard in cases involving statutory questions of agency authority. The court eventually decided that Chevron rested on a presumption that Congress when it left ambiguity in a statute meant for implementation by an agency, understood that the ambiguity would be resolved first and foremost by the agency and desired the agency, rather than the courts, to possess whatever degree of discretion the ambiguity allows. And that right there, folks, is the fox guarding the henhouse. Can you imagine the Congress actually intentionally drafting ambiguous statutes so that some nameless political bureaucrat can then steer the direction of the enforcement of the law? And that is what's been happening. And it's not exclusive to the ATF, folks. It is all of these runaway alphabet agencies. But of course, the problem was neither Chevron nor any subsequent decision of the court attempted to reconcile its framework with the APA. Chevron defies the command of the APA that the reviewing court, not the agency whose action it reviews, is decide all relevant questions of law and interpret statutory provisions. And so ultimately, where the Supreme Court has come down is they say, listen, it's one thing to respect what the administrative agency is saying or arguing. It's altogether different just to defer to them completely. Chevron insists on more than the respect historically given to the executive branch interpretations. It demands that courts mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time, and even when a pre-existing judicial precedent holds that an ambiguous statute means something. And so, yes, it is again a piece of legislation that was drafted in 1946 for more fair implementation of administrative rules that now gets us to this ruling. Chevron cannot be reconciled with the APA by presuming that statutory ambiguities are implicit delegations to agencies. That presumption does not approximate reality. A statutory ambiguity does not necessarily reflect a congressional intent that an agency, as opposed to a court, resolve the resulting interpretive question. Many or perhaps most statutory ambiguities may be unintentional. And when courts confront statutory ambiguities in cases that do not involve agency interpretations or delegation of authority, they are not somehow relieved of their obligation to independently interpret the statutes. And of course, if we take a look at how we structured our system of government, does an administrative agency who is under the purview of an executive, that being the president, really have any incentive to remain impartial? Of course they don't. They are trying to advance that particular president's agenda. And that goes for whether the president is a Republican or a Democrat. So as the Supreme Court pointed out, perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. So in sending the Chevron deference to its grave, the Chief Justice writes, "At best, Chevron has been a distraction from the question that matters. Does the statute authorize the challenge agency action? And at worst, it has required courts to violate the APA by yielding to an agency the express responsibility vested in the reviewing court to decide all relevant questions of law and interpret statutory provisions. Chevron has proved to be fundamentally misguided. It reshaped judicial review of agency actions without grappling with the APA, the statute that lays out how such review works. And its flaws were apparent from the start, prompting the court to revise its foundations and continually limit its application. Experience has also shown that Chevron is unworkable." And so ultimately, in the coup de grace, the punchline from the Chief Justice, the ruling of the court is, the only way to ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion, is for the court to leave Chevron behind. Now, as we know, there is a litany of cases that were previously decided upon the Chevron deference. Does that mean we get to do a do-over now on all of those cases? The Supreme Court has been very clear here that although they are going to change their statutory interpretation framework, that does not mean we're going to reopen any of the old cases, as the Chief Justice put it. By overruling Chevron, though, the court does not call into question prior cases that relied upon the Chevron framework. The holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite the court's change in its interpretive methodology. But like I said at the very beginning of this video, this case is one of the most significant rulings to come out of the United States Supreme Court in decades. This case will significantly change the fundamental structures of how our country is run. This case will actually bring the operational functions of our country back more in tune with how our founding fathers actually intended it to be run. This case actually begins to alleviate that fourth branch of government known as the administrative state. The case, once again, is Loper Bright Enterprises versus Raimondo. We're going to link it up down below so that you all can geek out on it for yourself. Hey, maybe you got questions about this. If you do and you need to get a hold of Washington Gun Law, all of our contact information is down there in the description box. Maybe you got an idea for a video we should be doing here at Washington Gun Law. If you do, go ahead and click on that link right there. Some of the best ideas we ever had, candidly, weren't our ideas to begin with. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.